Almost 41 years ago, Congress passed the Pregnancy Discrimination Act to guarantee equal opportunity for millions of working women. But I'm here to tell you that pregnant women in this country are still often treated as second-class citizens. Despite the promise of the PDA, pregnancy discrimination remains rampant in America and a key barrier to gender equality. One very common form, especially impacting women in low-wage and physically demanding jobs, predominantly women of color, is when pregnant women are fired or forced out rather than provided temporary job modifications that would allow them to keep working. Women often face an impossible choice: stay on the job and risk their health or lose their paycheck when they need it most. And unfortunately, at A Better Balance, we have heard hundreds of these stories from workers we've spoken with over the years. Women like our former client, Betsida Cruz Cardona, a cashier from upstate New York, who was told she should just, quote, stay home, take care of her pregnancy, and rest, after handing in a doctor's note with a lifting restriction, even though she could have easily been accommodated and desperately wanted to continue working. With no paycheck, Betsida wound up homeless and had to rely on family and friends for shelter, moving from couch to couch as she prepared to become a mom. The economic well-being of most Americans' families today is dependent on working mothers. When women like Betsida lose out on critical income, they not only suffer in the short term, they forfeit other long-term benefits earned on the job, contributing to their economic inequality and exacerbating the wage gap. When pregnant women are denied workplace accommodations, we know their health often suffers too. I'll never forget one pregnant cashier who was told she could not carry a water bottle on the job. She wound up in the ER due to severe dehydration after fainting and collapsing on the retail floor. Other health risks associated with failure to accommodate include urinary tract infections, fainting, preterm birth, low birth weight, and even miscarriage, evidenced by the experience of our client, Tasha Morell, who was featured in a front-page New York Times story last year. These options, risk your health or lose your paycheck, reinforce the stereotype that pregnancy, motherhood, and employment are irreconcilable and defy the purpose of the Pregnancy Discrimination Act. Almost 5 years ago, the Supreme Court addressed the application of the PDA to workplace accommodations in young. Unfortunately, the multi-step evidentiary framework established by the court's majority and the unique burden it places on pregnant workers to provide a wide range of evidence of non-pregnant comparators to prove their employer's intention was discriminatory has made it difficult and often impossible for pregnant workers to succeed in court post-young and get the accommodations they need. This standard is also tone-deaf to the realities of the American workplace, where pregnant workers typically lack access to their coworkers' workplace accommodation requests, personnel files, and simply lack the luxury of time and certainly the resources to sort out these questions. The ADA, by contrast, offers workers with disabilities the explicit right to accommodations absent undue hardship. They can completely bypass this burden of proving that a coworker was accommodated first. However, most pregnant workers with medical needs are not deemed disabled under the ADA and fail to trigger its protections. There is a solution. The bipartisan PWFA would address this gap in the law and fulfill the intent of the PDA. Specifically, the PWFA would require employers to make reasonable accommodations for employees who have a limitation stemming from pregnancy, childbirth, or related medical condition unless the requested accommodation would impose an undue hardship. The same familiar process in place for workers with disabilities. The PWFA would also ensure that a worker cannot be forced to take leave if another accommodation can keep her working and healthy. Like the ADA, the law would encourage a productive, informal dialogue between employee and employer rather than stressful and time-consuming litigation. As we know firsthand, this is precisely what most pregnant women need and want. They need clear rights and an immediate solution to stay that allows them to follow their doctor's orders and stay attached to the workforce. Requiring a pregnant worker to jump through legal hoops to get a medically necessary accommodation is a fundamental deterrent to justice and equality. State legislators on both sides of the aisle have recognized that accommodating pregnant workers is smart public policy as well and are taking action. As you heard, there are now 27 states from New Jersey to Kentucky that provide it. At ABB, we see these laws are working. For example, thanks to New Jersey's law, a public employee, Takira Woods, was quickly able to follow her doctor's orders and return to work in a light-duty position. Yet while states have improved workplace conditions for thousands of women, job protection and a healthy work environment should not depend on luck or location. The PWFA would finally ensure that pregnant workers in every corner of the country stand on equal footing in the workplace. No one should have to choose between her job and a healthy pregnancy. It's time for Congress to step up and pass this critical legislation. It's long overdue. Thank you.